Ladies and gentlemen, gentlemen and ladies and gents, I want to talk to y'all just for a little bit of second. Give us a moment, because we're going to talk about how the world is. Ladies and gentlemen, come on, Earth Wind, tell them. Sorry, gotta be careful because I can't be too loud, y'all know me. They're gonna talk about Hearts of Fire and Love Desire. Gonna let them catch up. Gotta turn this voice recognition off because it will come on. Give it a moment for me to make sure it's off. All right, it's off. Ladies and gentlemen, we got something we need to talk about. And so what I'm going to do is I'm going to turn down the volume on my end. That way Earth, Wind, and Fire ain't going to be too loud for neither one of us. This is just a conversation for those of you who are dealing with the courts. You tried to file a lawsuit and the courts will say things like, your lawsuit is ambiguous and nonsensical, and they can't comprehend it, and it's gobbledygook, and it's unintelligible and illegible that they cannot read, illegible that they cannot read it. So I had a judge do that. Two judges in the same court did the exact same thing, but I knew that they would do that. Ladies and gentlemen, in the month of November, I found out about ChatGPT. We're going to minimize this to take care of some strain on our system. Found out about ChatGPT. So since the court said it was unreadable and that the opposing party would unlikely be able to understand it, I went into ChatGPT and I said, I need you to tell me whether or not an 8-year-old would understand this. ChatGPT said the following. Let's go there and let y'all, Bard. We don't have the full thing about the Bard, because what happens is, ladies and gentlemen, I got to let you know, what happened is I refreshed it, so I don't have the first one. I did copy it, but this is what the complaint says. Introduction. The U.S. Bar, as defined by statute in the Federal Reserve Circular numero 10, specifically Appendix number 3, has signed an agreement with the financial institution authorizing the local Federal Reserve agent, i.e. the lender, via an irrevocable power of attorney in fact, to facilitate the depositing of the collateral security with the Federal Reserve agent for the advancement of Federal Reserve notes, to reimburse the Federal Reserve for the extension of bank credits supplied to them by the original lender to the original seller of the property to offset the transaction. Upon tendering the collateral security to the local Federal Reserve agent, i.e. the lender, such constituted accord and satisfaction in the form of a bearer instrument as defined in statute and consumer commercial transactions. Sorry, we got to get rid of this. No thanks. Get on out of here. This is not a mere conjecture, or this is not mere conjecture, but these are facts. The U.S. borrower applied to the local Federal Reserve agent as required under the Federal Reserve Act, Section 16, paragraph number 2, for the advancement of Federal Reserve notes in conjunction with the U.S. borrower. And with that, the U.S. borrower then proceeded to deliver via tender of collateral, because you got to tender the collateral of the promissory note, is cognizant the collateral and security equal to the total and full sum of the Federal Reserve notes that's applied for. Therefore, the home and or other property acquired after the issuance of the temporary credit by the local agent is nowhere noted in the Truth in Lending Act statement as necessary for the issuance of the loan, seeing how the note tendered to the local Federal Reserve agent amounts to the satisfaction in accord in agreement between the parties and thus satisfies the so-called debtor obligation. The reliance on the presumption that there is an outstanding debt when the lender presents and introduced to the court the collateral security with the borrower's signature documents their receipt of negotiable instrument in the form of the bearer instrument. And the agreement between the parties and the power of attorney in fact documents the fact that the bearer bond may be presented in that it allows for assignment of the promissory note, which the borrower has signed in blank before witnesses, including a notary. Okay, so I asked him just to explain this. I can explain the petition, what the petition is saying. Thank you! The petitioner, Mosley and EeON, they are filing a petition with the court to enforce an administrative order to obtain a stay pending the outcome of the case. The administrative order in question is the Presidential Proclamation 2039. This order requires the Federal Reserve to comply with certain regulations. The petitioners are alleging that the Federal Reserve is not complying with these regulations. The petitioners are asking the court to issue a stay pending the outcome of the case. A stay is a court order that prevents the Federal Reserve from taking any action that would affect the petitioner's rights. The petitioners are arguing, I don't like that word, that they are entitled to a stay because they are likely to succeed on the merits of the case. They are also arguing that they will suffer irreparable harm if the Federal Reserve is allowed to continue its noncompliance with the regulations. The petitioners are asking the court to grant the petition and issue the stay pending the case outcome. Here are some key points from the petition. Let's see if it was clear and understandable. The petition alleges that the Federal Reserve is not complying with Presidential Proclamation 2039. The petitioners are asking the court to enforce an administrative order and obtain a stay pending the outcome of the case. The petitioners are arguing that they are likely to succeed on the merits of the case. The petitioners are arguing that they will suffer irreparable harm if the Federal Reserve is allowed to continue its noncompliance with the Federal Reserve Act. That's just the first 6 pages of the document, ladies and gentlemen. This is what the court said was not clear and concise statements. Now, here's the thing. This is the unique part. The court said it was not clear and concise statement. Let me find... Dagnabbit, this ain't it. Give me a second. Let's see if I can find it. Because I had to do... What's the difference between a pleading and a petition? And that's the wrong answer right there altogether. That none of these are the definitions of a pleading and a petition. So I can't use that junk. Let's see if I can do it here, or is it here? Give me 1 second. Y'all don't mind, do y'all? I'm just gonna put your hands together, ladies and gentlemen. Put your hands together. The legal definition of outline. Ladies and gentlemen, outline and closing are indicating the shape of an object. That's not general description or plan giving the essential features of something, but not the details. Ladies and gentlemen, I do my petitions in outline format. So let's do this. I want just the outline, a summary of something. See, the so-called federal rules require clear and concise statements. So the courts have been saying that when we are adding the kitchen sink, that we're not being clear and concise. That's a lie. As long as it's in outline form, it is summary. Because it's in an outline form, it's not a continual conversation. It's going from one subject to the next. Clear and concise statements. So they can't use that anymore. What I'm trying to say is I am the presumption rebutter. They come up with a stupid presumption, I promise you I will find a way around it. It is called the loophole. That's what they're using, this loophole. So every time you look at a court case, you got to look at the presumption that they're presenting. And you have to get around that stupid presumption. If you can get around a presumption, they cannot handle you. Now they can't get around ChatGPT because it's a language model. ChatGPT is a language model. It lets you know it's an AI language model. It's not AI. And that's a misnomer. It is not intelligent. It is just a language model. It just puts together words. But if it, being a language model, can understand what I'm writing, then so can a person who is sentient. That's all I'm saying to the court. And I'm asking the judge to recuse themselves. And since 2 judges have done this, I can't tell you the exact strategy that I planned. I told you this has been a plan, ladies and gentlemen. I'm working this out every single day, and it's causing me a great deal of stress. But the stress is not the courts. The stress is I gotta be patient in processing this because I'm getting ready to bring in one of the largest lawsuits ever known in this country. And I'm going to be using the same tactics I'm using here. I'm tired of them frankincense with me. I've had enough. They want to play with me, I'm going to play back. Oh, by the way, when the judge decided that it was unintelligible and eligible, okay, and not legible, illegible, then what I decided to do, you want to tongue twist my tongue, I said, look here, mother, since you want to play that game, by the way, here are the rules. Here's the definition. You're a judicial officer. I put you on judicial notice. I asked you for subpoena signed in blank. Your clerk of the court didn't do that. Don't worry about it. Here I come. That's what I told him. I'm not threatening a judge. I'm just letting her know. Letting him know, her know, I don't know if it's a male or a female. You fools keep playing with the wrong fool. I'm not afraid of you. You're not scaring me. What you need to understand is everything you just said was a lie. And I can point it out. And that's all I did was critique their stupid motion. And I used logic to kill their stupidity. They are seasoned judges. So that's why I asked it before if a 1-year-old law student would understand. And if a judge, having been seated on the bench for a year, would understand. See, ladies and gentlemen, we did a cover letter explaining things clear and concisely, exactly what we were needing. And they ignored it. We told them our filing was intellectual property. You don't have the right to change or augment or alter our caption. That's ours. We created it. You don't get to recreate our caption, which is what the court does, so that you can be submitted to their jurisdiction. That's why they put the name in all caps. So that's why we came in our natural capacities. They took us out of our natural capacities, didn't even use the word. So I will take care of that. Not a big point right now. I just wanted to share this with you guys, let you know that there are ways around their stupidity. Do not give up because they keep trying to hit you in the head. Do not give up because they keep trying to hit you in the head. Sorry, I'm moving some files over because this was full a moment ago, but I have moved some things around, and so it ain't full no more. Hey, y'all hear my boy in the background? That's Michael. He's going to take us on out of here. I just wanted to share some things with some of y'all because some of y'all are losing faith. Some of you are losing hope. You're sitting up there giving up because you're running into roadblocks with the courts. You guys need to understand, you're not supposed to be giving up. They want you to give up. They're coming after your homes. You go after them. I don't mean violently. No, I mean with their own codes, their own laws. But I don't know what to do. Stop saying that. All you got to do is exercise your right to petition government for redress of grievance. That's all you got to do is focus on. The Supreme Court has held that no one can convert a right to a privilege. Hold on, let's see. Which one is it? I think we're going to do... It has clients' names on it, so y'all have to excuse me. I'm going to pause it and I'm going to show y'all. In order to enforce an administrative order is an administrative proceeding, ladies and gentlemen. It's a summary proceeding. Whenever you hear a summary proceeding, that's administrative. It's the court's administrative system. This is Cameron versus Corporation Commission. It is generally held that an administrative agency may not deprive, nor may a statute empower them to deprive a person of his constitutionally protected right without notice and hearing. A statute or administrative rule may not take away or infringe upon the rights guaranteed by the Constitution. We are unaware of any other proceeding so profoundly affected by personal and property rights since the case of blah, blah, blah. This is the case where the Supreme Court held that due process requires at a minimum. This is a California case, by the way. See, Superior Court, California. It's a California case. That at a minimum, a person has a right to a hearing. At the bare minimum, they have a right to notification of such hearing. Okay, ladies and gentlemen, we present that the decision made by the judicial officer was an administrative one and not a judicial act. And the reliance by the judicial officer on the presumed principle and or rule that prohibits anyone but an attorney from speaking on behalf of another party or a corporation is an infringement upon a right of the corporation and or the parties, whether or not engaged in commerce, as that would be a prohibition defined by the First Amendment and an infringement on the right to access the court. So it operates as an infringement on the right to access the court. They cannot come up with a rule, and that's what the courts have come up with, a rule saying corporations can only be represented by attorneys, that persons can only be represented by attorneys. Ladies and gentlemen, that's a lie. That is not true. The Constitution said counsel of choice. There's a difference between counsel and an attorney. They are not synonymous words. They never were synonymous. So let's do that. That's the last one we're gonna do. So y'all just hold on now. I ain't doing all this for my health. Hold on, I'm tired. I'm going to sleep. It has been held that counsel and attorney are not synonymous. Comma, can you explain why that is? Question mark. Sorry. Stop listening. Stop listening.
Sure. Counsel and attorney are often used interchangeably, but they are not technically the same thing. Counsel is a general term for someone who gives legal advice. It can refer to a lawyer, but it can also refer to a paralegal, a law student, or even a friend or family member who is knowledgeable about the law. Attorney is a more specific term for a lawyer who has been admitted to practice law in a particular jurisdiction. Attorneys are licensed by the state and have the authority to represent clients in court. In some cases, the term counsel may be used to refer to a group of attorneys who are working together on a case. For example, a law firm may have a counseling department that is responsible for providing legal advice to the firm's clients. The distinction between counsel and attorney is important because it can affect the rights and responsibilities of the person giving legal advice. For example, an attorney is required to follow the rules of professional conduct, which are designed to protect the interests of their clients. A non-attorney, such as a paralegal or a law student, is not subject to these same rules. Here are some of the key differences between counsel and attorney. Counsel is a general term, while attorney is a more specific term. Counsel can refer to anyone who gives legal advice, while attorney refers to a lawyer who has been admitted to practice law in a particular jurisdiction. Attorneys are required to follow the rules of professional conduct, while non-attorneys are not. I hope this explanation is helpful.
Ladies and gentlemen, that's why the right to counsel is so essential. Do not let the police offer you the right to an attorney. Excuse me, you don't have a right to an attorney. That's a privilege to an attorney. You do not have a right to an attorney. You have the right to counsel of choice. And you all need to start challenging that and stop letting them come up with rules that prohibit you from exercising your right to counsel of choice. Okay? This is how the ties that bind. This is how they gain that type of ignorance and control. All right.